Good afternoon, everyone. Thank you for joining today's presentation on corporate counsel's use of arbitration and mediation. My name is Sanjeev Dhawan, and I'm on the board of the ACC's Ontario chapter. I hope everyone is staying safe and healthy during these historic and challenging times. We're expecting a very large audience today, so thank you for all attending. Before we get started with our extraordinary panel, who has a wealth of experience, I just want to say a few words about the ACC. The resources of the ACC are second to none. And at the ACC Ontario chapter, we aim to be your primary global association for in-house counsel. Our primary responsibility is to our members. We continually strive to develop resources and programs that respond to and anticipate members' needs. During these times, as a professional association, we are developing the programs that are important to you. At the chapter level, we recently are coming off a session on cybersecurity as well as our securities law symposium. At the global level, we just recently had our ACC annual meeting, which was a 4-day program, and it was held virtually. So all to say, it's a good time to become a member of the ACC. If you're not already a member, I encourage you to become one by visiting acc.com. I want to thank Goodmans for sponsoring today's program. As I mentioned earlier, today's panel is extraordinary as we have not one, but 2 former justices of the Supreme Court of Canada with us. We also have a very experienced and skilled arbitrator and mediator. So it promises to be a very engaging and most importantly, informative program. When you received instructions for today's webinar, you also received a link to a feedback form. Please try and complete this feedback form because it'll tell us what you think about the program and it'll help us in developing future programs. You'll also receive a copy of this link later in the program. Our moderator today will be Peter Ruby. Peter is a partner at Goodmans, well known for litigation as well as arbitration with respect to a wide variety of business disputes, and he's a former adjunct professor at the University of Toronto Law School and Osgoode Hall. He also acts as an arbitrator and mediator, primarily in the technology and energy industries. So I now turn it over to Peter Ruby.
Thanks very much, Sanjeev. When a law firm sponsors one of these ACC events, usually we combine some education about a legal issue with showcasing some of our fantastic lawyers. But during COVID, we wanted to give you something that was out of the ordinary, really geared to what we're all living through during this pandemic. And since one of the side effects of COVID is that the courts are currently handling business disputes on a more restricted or limited basis, it seemed a good time and a relevant time to revisit arbitration and mediation as alternatives to going to court. And we thought about who would be the best individuals to discuss these alternatives. And we certainly wanted an individual who focused on acting as an arbitrator in Canada and abroad, but who'd also served as a judge. We wanted someone who was focused on acting as a mediator, but also had judicial experience that could be used to compare and contrast different dispute resolution processes. And we wanted an arbitrator and mediator who'd done a great deal of writing about these fields. And I'm delighted to say that our panelists fill all of those requirements on a superstar basis. We have with us the Right Honorable Beverly McLaughlin, who was the Chief Justice of the Supreme Court of Canada and now focuses on acting as an arbitrator. As well, the Honorable Thomas Cromwell, who was a Justice of the Supreme Court of Canada and now focuses on mediation. And not at all least, though last on the list, is Daniel Erdes, who's a highly respected arbitrator and mediator and the author of what is often considered one of the best arbitration blogs in Canada. In the nature of or service of full disclosure, Beverly, Tom, and I are all on the roster at Arbitration Place, a leading arbitration center in Canada. And Dan and I have gotten to know each other well over the last few years, and I've come to learn about his exceptional creativity. So with that, let me just say before we get into the substance that our panelists have agreed to take questions as we go. So you don't have to wait to the end. Please use the Q&A button that you've probably all become familiar with these Zoom webinars. And for those of you like me who've appeared before Beverly and Tom in court, please seize this opportunity to ask them questions instead of the other way around. So today we're going to focus on the types of bread and butter agreements that corporate counsel often work on. And we're going to leave aside, just for the purpose of today, employment and consumer matters. They have a different aspect when it comes to talking about arbitration mediation. So we'll try and stick with more of the regular corporate commercial type situations. And just to get a feel for what the scope of mediation and arbitration deal with in this subject, Tom, Dan, and Beverly, can I ask each of you in turn to tell us a short story about one of your favorite arbitration or mediation experiences? Tom?
Thanks, Peter. Happy to lead off. I think that my story is about the importance of not overlooking the basics. And I was involved in a mediation of a very large claim with very sophisticated parties, with counsel in Canada, the US, in Asia. We were all assembled on Zoom for many hours, and we seemed to have stalled. And so I went to the defendant side and, among other things, mentioned the likely costs of proceeding with the matter to litigation, and was immediately set upon by in-house counsel, asking me where I'd got that number and that this was not their understanding, et cetera, et cetera. Of course, I, in fact, got the number from their own counsel, external counsel, but didn't want to indicate that at that very moment. So I sort of weaved and bobbed for a few moments and then left them alone with the suggestion that they might want to discuss that matter further. About 20 minutes later, I was summoned back into the room. It turned out that there had been a complete misunderstanding of the situation, that the number I had mentioned was in fact at the conservative end of the estimate that had intended to be given, and the matter settled within the hour.
Terrific. Dan?
Hi. I guess one illustration is to underline that the agreements to arbitrate, people call them a clause, but they're really a separate contract. And the arbitrators, if there's a panel of 3 and they have all sorts of rules, they can't change the wording of the clause. And there was one institutional arbitration that I was involved in as the chair, and I had 2 other senior arbitrators from different ends of the country. And the clause stipulated that the location of the hearing would be in a city that combined the name of an animal and a body of water. Now, in Canada, if you ever have the name of an animal and the body of water, you're far from anything. So we decided to encourage them to at least hold it, somewhere central like Toronto. And we were trying to get people to come to Arbitration Place. And this is not a plug for Arbitration Place. It was what we were actually doing to help the parties get a resolution. And one of the parties insisted that they have it in this little town. And we said, why? And the attorney was on the line alone for all these calls and said, well, it's my client's right, and they insist on it. So we said, fine, we want you to cost all our flights and meals and hotels just to get to this one location, then to fly up to that one city the extra night, the cost of the one hotel in that city and the cost of the one convention center in that city. And then 10 days from now, give us your client's comments, which implied that you have to ask your client's comments so they can give them to us. And then 2 days later, we'll have a hearing and decide if we can arrange something different. And in 10 days, we got an email saying the client had renounced to their contract and they'll hold it in Toronto because they realized that the agreement, even though they could say it would be held up there, they would drop back and modify it. And it required a modification by the parties because it is the contract, not something the lawyers can amend or the arbitrators.
Thanks, Dan. Beverly?
Well, my little story just focuses on how arbitrations can vary and how even complex matters can be decided in a quick and flexible way. I'm involved in a number of international arbitrations, and I've had at least one very long and complex national one. And sometimes one gets the feeling that the process is extremely long and formal, and it takes you years to get to the hearing. And then finally you get there and everything seems to come together quite quickly. But I had a different experience in the last few months, a very complex matter, international dimensions. The parties decided that for whatever reasons we weren't privy to, they had to get a decision very, very quickly. So to make a short story even shorter, within a period of a month, we had all the pleadings, we had the expert exchange, we had the document exchange, and then the big hurdle was, well, we can't go to the designated place. So everyone agreed it has to be done virtually. We had a 3-week hearing, which is pretty long, virtually. And now, having just completed that, we're in the process of getting the arguments, and we will have a decision out. We have to have a decision out well before the end of the year. And all this will be made possible even on a very complex matter. So I tell this story simply to say, arbitration is what you can make it and what you want it to be. And we sometimes feel that it has to be this very, very long process, which is going to take 2 years or whatever. But it can be much more flexible and much quicker.
So if you'll forgive me, the 3 stories you've just told reminds me of one of my own experiences during the .com boom in the late 90s. I had a client where actually the parties on both sides, there wasn't a single person at either company over 22 years old. And their arbitration clause was that they were going to appoint somebody in Las Vegas. And if there was a dispute, everybody would fly to Vegas and the arbitrator would flip a coin. And that's what they put in their agreements. 15 years or so later, when everybody had matured a little bit and the parties had a dispute, they quietly agreed to just ignore that provision and come up with maybe something in between that and Beverly, what you just described, that is short, but not quite flip a coin territory. So as you've alluded to, corporate counsel usually have to choose their dispute resolution agreement or provision at the time they're making the contract and well before any dispute arises, or they even know what the dispute might possibly be in many circumstances. So I thought we'd take a minute and try and help the folks on the phone with some tips when they're before they're drafting contracts, when they're trying to figure out whether to put an arbitration or mediation clause in their agreements, what they can be thinking about. So maybe Beverly and Dan, we can start within your practical experience. What do you see as the most important advantages of arbitration in this milieu, this commercial corporate context?
Well, I'm by my history a judge, and I was always a little regretful that some of the most interesting commercial and construction law disputes when I was a judge were going to arbitration. But I certainly do think that this is the way to go for a number of reasons, depending on the nature of the dispute. If you have an issue of law that needs to be clarified, not only for your case, but for other cases, but a real issue of law that you want an answer to for future practice, then you should go to the courts, because the confidential nature of arbitration, the lack of precedent, etc., being set out will not give you the answer you want. If, on the other hand, you have a fact-specific, evidence-heavy, but not necessarily evidence-heavy, but a fairly fact-specific thing, and you need a quick decision, arbitration it may be preferable. As my little story I started with indicates, if the parties have a will and motivation, they can make arbitration, usually even on complex matters, happen quite efficiently and quickly, and that is the advantage of speed. Now, I appreciate that doesn't always happen, and some arbitrations are quite lengthy, but you can have the advantage of customized rules, customized time limits, customized approaches, so that you can get what you want, which is a decision, in a shorter time than courts. You may be able to save money. Usually, if you use the rules properly, you will, but that can be debated on both sides and depends on the case. Confidentiality is a big driver. So if you're if you're thinking, we don't want to share the details of this dispute, or our books, or our practices, or our special private information that the world might like to have on IP or something like that, if we don't want that broadcast around the world, then we would opt for an arbitration, I think, rather. You can have some enforcement benefits internationally. International arbitration offers enforcement through various mechanisms, which we're all familiar with. And you do have, and this may be a pro or it may be a con, but you're probably going to get finality, no appeal. So those are just a few. I'm afraid I've gone on too long and not allowed my colleague to come in with others, but he'll find some other advantages that I haven't mentioned, I'm sure.
I'll make some up. No, I agree entirely with what Bev just said, and I'm using this opportunity, everyone, to use Tom and Bev's on a first name basis here, and I'll revert back afterwards. But I totally agree with what Bev said. I would also add there's some peculiarities with the arbitration process that you can't get at court. One is to identify the type of decision maker you want in advance. So you can elect to have a specialist, an accounting specialist, or an IP specialist like Peter. All these specialties, so you have someone who's learned in the subject matter. And it's a fine line, because sometimes you might choose someone who has a strong finance background as a condition of being named an arbitrator, except the dispute turns out to be an IP problem. So you might have chosen the wrong arbitrator's qualification given the nature of the dispute that came along. So with every right you exercise, you might misstate it in the clause. So be careful about that. The other things by having someone who's learned in the matter, you have someone who's able to cut down on procedure, because he or she will be able to say, that's totally unnecessary, that step, or you can refine it, simply because they don't have to reinvent every issue, knowing that they are not material to the eventual decision. So that's the benefit of choosing your decision making. Faster decisions, yes, of course. Be careful. In Ontario, you have domestic and you have international. Domestic, you get the luxury of having it confidential, except you lose that luxury if there's an appeal provision or the right to at least apply for an appeal. Whereas in Quebec, it's one-stop shopping. It's game over after the decision, subject to the standards that apply in international rules. Confidentiality is obviously a major benefit, unless you need to pass a message to the market, like going in the courts and letting everyone know that you're asserting your rights. And if you need to enforce patent rights, you might need to go into the courts if you want to declare a patent invalid. An arbitrator can't do that, so there's some limits. Cost savings is, people say you're going to save money. The nuance in arbitration is that it's like building a house. You're going to pay for it in 8 months rather than over 10 years. The other thing is litigation gives you the appeal and the appeal. So your bungalow becomes a 2-story house on the first appeal, and a gray story walk up on the third when you get to the Supreme Court. So you can go further in litigation, but it's not really cost savings in first instance in arbitration. You simply spend your money earlier. And if you have the right arbitrator, the arbitrator will cut down on procedure. It's a lighter procedure and it's more targeted. So there are some benefits, but it's still a bit costly. So those are the ones I would add to Peter.
Terrific. Do you find when you have the larger arbitrations that the elimination of the home court advantage, in the sense of you can have the dispute adjudicated by 3 people from 3 different countries or even 3 different legal traditions, does that make a difference sometimes as compared to ending up in one court or the other of a country?
Well, I can come in on that. Oh, sorry.
I was going to ask Bev to go first.
Yeah, I am on a number of panels that involve people from arbitrators from different countries. And I can tell you, I think it adds, if you have a truly international dimension, it really adds a lot. You're getting different perspectives, and you're listening to each other. And as an arbitrator, you can ask the person who, for example, comes from the country in question, well, is this how you do things? What are the processes? What do you think of the law that they're presenting on this, if that's the applicable law? And then you have these discussions where I think everybody is obviously following the clause in the agreement. You're applying the law as per the agreement, etc. But you bring all these different perspectives, and I think the parties can have a really good high level of assurance that there's going the 3-person tribunal with people from different countries is going to really appreciate the real dimension of the problems, the real nature of the law to be applied, and that you'll get your chances are you'll get a better, more responsive award.
Perfect.
I think my only qualification is I love the idea when I'm working on panels with people from other jurisdictions, because it does inform me of the party's expectations. If someone is in a civil law country like continental Europe, locations, South America or Asia, they have a very different approach to their transactions and their contracts. And it's good to have a panelist who will share you some insights, because in arbitrations, you're trying to give the people the justice that they signed up for, not to be complacent and do something that pleases them, cutting the pair in half. What you're trying to do is have them understand that they got the case heard the way that they feel that they could make their case. And many international companies are able to be flexible in how they present their case, but having a panelist, like Bev said, is vital. The downside to having 3 is just the length of time trying to find everyone's schedule. It's like calling 3 popular friends and asking them for dinner. It's not next week, I can tell you that much. It's going to be a while.
So Tom, if we asked you a similar question about mediation, why mediate business disputes between sophisticated parties that probably have a lot of experience with negotiating all kinds of issues? Why mediate?
Well, often, of course, mediation offers many of the same advantages as arbitration in terms of privacy and confidentiality and choice of the person that you think may be able to facilitate the settlement. But I think that the presence of a third party often helps focus the attention. The fact of having to prepare a brief and put together documents and try to educate a neutral third party about the dispute in preparation for the mediation imposes a discipline and brings an attention. to the matter. And of course, the advantage of a mediated settlement is control. When you go to arbitration or if you go to court, you're basically giving somebody else the keys to your car. And in mediation, you get to hang on to them at least until the prospects of settlement are exhausted. A very wise person that I used to work for many years ago used to say, I'd rather live with my own mistakes than somebody else's. And I think that that's perhaps where those are words to live by for people thinking about mediation, that they will ultimately maintain control over the fate of the dispute. Another advantage, I think, of both mediation and arbitration is particularly mediation is taking off some of the time commitment that litigation imposes on often senior people in a company or leadership of an organization. Those folks just love spending 2 or 3 days in somebody's boardroom preparing for discovery or whatever the process is, let alone answering demands for production and so on and so forth. So while it's important for mediation for the parties to know enough about each other's case that they feel they can sensibly assess their risks, you can often avoid a lot of those big costs of litigation through discovery, oral discovery, and even heavy document production. So I think that the other thing I would just say about the possibilities of mediation is, well, we think of mediation as mainly about settling cases. I think parties are also exploiting mediation for other purposes. I mean, obviously nobody minds if the matter fully resolves, but they may be going into it more from the point of view of trying to get the other side to bring their attention to the matter. They may be looking at mediation as a form of inexpensive discovery. And mediation may well be the first step along a road that will lead to a settlement. And I'm sure my colleagues have all had the experience that I've had a number of times where you spend a day or two with some parties and you don't seem to get all that far. And then 2 weeks or 2 months or whatever later, you get a call, could we have another day? And all of a sudden, things are now more focused and we're ready to move along. So I think that while we tend to think of mediation as, we're going to go into that room and come out at 5 o'clock with a deal, I think mediation can serve more intermediate purposes along the way that may get you there, but may not get you there the first time out.
Dan, when you're acting as an arbitrator, do you ever suggest to the parties that they mediate or raise that possibility with them?
All the time. Some parties are reluctant to propose it because they'll perceive it as a sign of weakness or a loss of confidence in their own position. So to facilitate it, I will regularly urge them to do it, knowing it could fall on deaf ears, but I will provide them with the coordinates of different mediators as they go along. So they at least have the excuse of saying, look, the arbitrator suggested it, what do you think? And they might be desperate to settle. And it does work. It also works the closer you get to the hearing, simply because, like it or not, the litigation process, the dispute resolution has extensive opportunities to clarify your case, from the demand letter when you're all gung-ho to when your client does some unexpected admissions during the examinations or depositions. The more information you get, the better your vision of your case gets. And it's even at the eve of trial, it's literally said that many cases settle at the court room doorstep. So at any point, I would urge them, like after the first case management, after the first procedural orders leading up to the hearing, the eve of the hearing, saying, look, the point of this business that we're in is to resolve it, not to give a life of its own. And if it's one of those things, I know lots of mediators, and just to be able to be told that it's okay, I don't mind, go ahead, settle, it gives the parties that encouragement.
Let me ask the three of you some questions that really go to sort of quality of justice points with these alternative procedures to go into court. So years ago, there were concerns that arbitrators were too often not making hard decisions that would result in one side or the other losing completely. Just let me start with you, Dan and Beverly. In your personal experience, when you're acting as an arbitrator, do you have any inclination to give each side a bit of a win?
Well,
Dan?
I'll go first. I absolutely not. I just, maybe I was a judge too long, but no, I try to call it the way I see it, and be fair and apply the law as best I can, and where it comes out, and that is my approach entirely. And I think most of the arbitrators I talk to share the same view. I'm on panels with other arbitrators, and no one's ever suggested that we have to give each side a little. What we do try to do is be scrupulously fair. And there's a real effort to do that on mediation. There is, of course, in the courts as well, but mediators really feel that they are appointed by these two parties, and in a very direct sense, they feel we have to be really fair to each of them, and so, but not to try to split the difference on a particular issue.
Okay, Dan, if I could for a moment play unregistered therapist for a moment in your own head, do you ever feel any pressure to do anything but come down in whatever way you think is the correct answer?
You know that people would be happier if you made their lives easier, but that's not why you're paid the big bucks, as they say. They've come to you for a result, and unfortunately, the result might please it. On Monday, I released an extensive award, and I annoyed both parties because they each had competing claims, and I just said, sorry, it doesn't, your arguments, if you look at the facts, just don't make sense, and I have to face them next month because there's a follow-up to it, and I just know it's going to be an awkward meeting, but at least it's 3 weeks away, so it's tempting, but you can't act on it. I think years ago it might have been possible to expect a repeat appointment because you made everyone happy, except nowadays repeat appointments are a sign of lack of impartiality. So it's short-term thinking, and I don't think it's current anymore.
So Beverly and Tom, maybe we can draw on your experience as judges for a moment. And I have a question for each of you. So Beverly, is there any difference between the way judges and arbitrators make decisions on the merits? You've explained the process is different, but you think any differently about arbitration or when you were hearing cases in court?
Not really, no. Legal issues arise, evidentiary issues arise. When I'm deciding the evidentiary issues, I try to apply the same techniques and the same rules as I would if I were a trial judge, and balance of probabilities and all of the other various rules. The evidentiary rules are often more relaxed, which is nice. And can be very beneficial. And there are many techniques that are terrific that you don't have in court, like the colloquial call expert panels, called hot tubbing, for example. This is just the way expert evidence is handled in arbitrations is, in my view, often much more efficient and gets you to the bottom of the matter much more quickly than in a trial. But nevertheless, in evaluating that, you're still acting like a judge, at least I speak for myself. And similarly on issues of law, we listen to the legal arguments, we crack the books, we try to, in reason, set out how we decided different legal points of view. And as everybody knows now, arbitrators have to give reasons like judges. So I find the process very judge-like.
So switching over to mediation, Tom, for a minute. If you were acting as a mediator where I was counsel, boy, would I be tempted to ask you what you thought about the merits, that is, to give us an informal ruling. Does that happen a lot to you as a mediator?
Well, first thing I'd say, Peter, is careful what you ask for, of course. But yeah, of course it happens a lot. I mean, people don't hire former judges because they weren't judges. But on the other hand, I think in the mediation process, at least I feel strongly that you have to use that part of your experience in pretty small doses. Because for one thing, your ability to know the case thoroughly enough to really give an early neutral evaluation that you'd feel confident in is often quite limited. And also somewhat times that can get, being too rights-oriented too early can get in the way of letting the parties figure it out for themselves. But I would say that in every mediation I've done, at some point, I either volunteer or somebody asks, how do you think this is going? And I invariably give it with suitable caveats. And sometimes, most of the time, I think if it's timed properly and is surrounded by enough realism, it can be very helpful to parties, particularly if there's a difficulty between a client and their own counsel, with expectations being absurdly high on the part of a client. Hearing that from a neutral third party can be quite helpful sometimes in getting it done. Occasionally, I think lawyers have started to drink the Kool-Aid about their case and need to be reminded what might be in it, and so on and so forth. So I think the answer is a qualified yes, that I think that former judges have a role to play in helping parties assess their risk realistically, but I think it has to be done with restraint and with humility because of the nature of the setting.
So Dan, besides helping with risk assessment, what are the other skills that you find mediators bring to the table when trying to help parties with a dispute?
No one comes to me to mediation to tell them what will turn out. I don't have the gravitas of Tom and Bev, so they sort of skip that awkward moment and just ask, to get into the mediation. So I don't have to carry that burden. My role is simply to listen carefully to what really is at issue, and it goes to the intangibles, what I call the loss of executive time, focus. Internally, there might be some problems now with manufacturing and finance. So there's a lot to look at before you get to the mediation. Find out what's annoying you. And for example, one in mediation, we took the case from the court to a settlement simply by looking at the last 60 emails of the exchanges. And it turns out what really bothered one party was the fact that the media had really taken up the fact that they had been sued by another company, and the other party just really annoyed. So the deal was, well, how can we address that? Not the merits of the IP dispute, but how to deal with that. So I wasn't asked about the merits of the IP. I wasn't asked about the results, which was overseas in a country I've never even traveled to. They said, what can we do? And just looking at it, I said, I think what you could do is offer to do a cross license and then put it into the media. And that actually helped bring a solution, which was not actually what the litigation was about. So listening to the people to find out what they want rather than what this case will bring them. I think that's important.
So we're going to move in a minute to talk a little bit about contract clause or agreement drafting to try and provide the corporate counsel who are participating some tips. But I remind you, just before we move on to that, you're more than welcome to hit the Q&A button and ask questions. And we in fact have one that's come in that sort of fits what we've been talking about, where they'd like to know from you in commercial contracts, when one party has less bargaining power than the other, for that party, do you think that tips the balance in favor or against going to court? So you're the party with less bargaining power. Do you want to go to court or arbitration? Who'd care to leap in first?
Well, I don't, just off the top of my head, it's an interesting question. I don't think it would make much difference. I think you're sure that in court, you will, certainly the judge will not, will give you a fair hearing, but you should be careful of that. You should be assured of that with an arbitration as well. And so I don't know quite what is meant by if the lack of power comes from the merits, the lack of merits in your case, well then you're going to have a problem. But I'm not sure that I think it would be all that different in one case or the other. There are these special situations in forum contracts where there are clauses that all cases have to go to arbitration, and you're talking about a $15 charge, and it's a class action, and that's a whole, and they don't have any bargaining power. That's a whole nother issue, which I don't think we want to get into today. But it's certainly, I think you should be able to get a good result on both.
Okay.
I think I would tend to suggest arbitration for the possibility. I bet Bev was mentioning a few minutes ago on other issues about the flexibility of the process. And one thing you get in arbitration is you see the same decision maker repeatedly. So he or she starts to size you up pretty early in the case. So someone who flexes their muscle too much over the littler guy, or is saying, holding out for the ultimate of justice at every point, you start to value that or weigh it as you go through at each step about, is it necessary? Is it appropriate? Is it proportional? You're not there to deny a large party justice. It's just saying, is this really necessary? And the strength of the courts is that they're all highly talented, experienced attorneys with years of trial experience. The difficulty of going to court is you end up explaining the same issue multiple times. Each hearing is longer because you have to put the judge, to get the benefit of their knowledge, you have to get them back into the story. Whereas an arbitrator, provided they have the same level of competence as a judge, it's quicker. It's the sixth phone call. He or she knows what you're talking about. So the fees are less. The arbitrator is sort of getting a sense of whether one party is overusing its size or not and can adjust things. So if I had to say to give a choice, I would do in that one instance arbitration. But I think from the get-go, there's not one that is automatically better than the other.
So let's try and talk about arbitration clauses for a minute and try and give people some, maybe we'll call them quick hits, quick advice. And I have a reason for raising this. I've been practicing now 25 years and have shifted from doing really everything in court to probably 50% of my practice is doing arbitration and mediation. And I admit to really not being keen at being handed these long arbitration clauses that go on for pages and pages. And that's whether I'm acting as counsel or as an arbitrator. And so let's see if we can give some crafting tips. So maybe we'll start with this. Dan and Beverly, any guidance on when to use ad hoc clauses as compared to institutional clauses? And maybe Dan will ask you to maybe start with refreshing us about the terminology.
One thing, I know that we have many corporate counsel from across the country in large and medium, small enterprises. You have to remember, as a risk managers, you are very good friends with your executives, and they want the deal done. And we've all heard about being a deal maker, deal breaker. But at one point, this is a key contract. It is not a clause. It's called a clause, but it's a contract. And if you do not treat it as a separate contract, you're doing a disservice to the people. So there's a there's 10 elements that Bev and I ran through about confidentiality and neutral decision maker. There's those elements, they should be top of mind when choosing things. So when the 11th hour comes in and someone says, oh, I want to do arbitration, the other side's agreeable, can you just send me a text? It's the equivalent in professional negligence of answering someone's question when they say, hi, I'm selling all our division's IP. Can you just send me a draft and I'm just going to fill it in? That's the level of negligence you're doing. So not one clause fits all. You need actually to talk to someone like Peter just before you do ink it and say, you know, I'm thinking of doing it this. And Peter, someone at his level, has been through it a number of times and can say, well, I think you should actually switch it from that institution to this, or go ad hoc. So my preference, ad hoc gives me more freedom as an arbitrator. It lets me tailor things. But institutional, obviously, there are excellent institutions out there in Canada and abroad. The idea with going with an institution, it's like going to the grocery store. You know, everything's there. Whereas ad hoc, it's like going to a farmer's market. You have to sort of pick it out yourself. So you really are at the discretion of the arbitrator if you don't really set up the rules in advance. But there's a lot of ad hoc done in Canada, especially in Ontario.
Beverly?
Well, I think I would echo that parties should really give a lot of thought to the alternatives. And then settle on what they think would be best. Sometimes you see these clauses, they have everything in them. They have mediation, they have arbitration, they have many, and it may not be necessary that you have everything, or and similarly, especially if you're in the international arbitration, there are different seats, shall we say. There's Paris, there's London, there's Middle East, there are different organizations, the ICC, through which these arbitrations tend to be channeled. And you have to give a lot of thought to which one you want to go with, because they have very different procedures. And so I think that this is an area that is much underlooked and underestimated. And even the Singapore International Commercial Court, on which I sit, it has another alternative which may work for some people, which is that you can have a court which operates a lot like an arbitrator, but has a limited right of appeal and is very efficient and fast. So there are different options out there. And I think that in-house counsel or counsel advising should really be sophisticated about drafting these clauses and make sure the people get the right thing. Ad hoc is often what is perfectly fine, because as well, especially on in national or provincial level disputes, because people will be able to hopefully come up with what they want. But I think the message I would say is think about your institution, think about what you're trying to accomplish, and inform yourself as to the options, and then choose what's right for you or tailor what's right for you.
Peter, just before we leave, last week I think I shared with Bev, Tom, and you a draft that came out of the New York State, and it's a very lengthy 4.5-page document. And just reading it, it sounds, wow, it must be good. It's got lots of words in it, isn't it? They must have thought about it. And it's tiered, you mediate, and yet the choice of the arbitrator is defective, because it gives each party the option to choose an arbitrator, but if they don't agree, it's from a pool of arbitrators identified by one of the parties. And I just think that is void right from the get-go.
So that leads to a good question. Tom, maybe we'll start with you. What do you think of these staged dispute resolution clauses? You know, the ones that say, you know, first the vice president has to talk, and then the presidents need to talk, and then there's mediation, and then maybe there's arbitration when all that's complete. Do you have a view whether that's a good idea?
Well, I do, but it's maybe a bit nuanced in the sense I think it it can serve a purpose, but it also carries risks with it. I think that the downside is that it overcomplicates the handling of the dispute and may even set up a whole bunch of technical objections depending on how it's, you were 2 days late going to step 48 or whatever it is of the dispute resolution process. So there are some pitfalls there, I think. But on the other hand, some sort of staged dispute handling process can serve a valuable purpose of making sure that the dispute gets attention at a high level in the organization early, and doesn't float around somewhere for a year and a half before anybody really understands what's going on with the dispute. So I think to that extent, it can be extremely helpful. And I also think that for many disputes, relatively early outside third-party intervention can be helpful. Obviously, the dispute has to have got to a point where the parties feel they know enough about it to make some assessments of their risks. But sometimes the requirement to go to an outside third party fairly early in the life may get that focus early, as well as save some of the enormous costs of litigation preparation. The only other thought I would throw in, Peter, if I might, is that parties in our legal tradition have a lot of flexibility open to them in terms of fashioning their own dispute resolution processes. And my sense is that parties generally are not taking full advantage of that, particularly parties that deal with each other on an ongoing and regular basis. That there are many opportunities to craft a process that really would work optimally for those parties. And I would like to see a lot more attention given to exploiting some of those possibilities.
I think, Tom, you've just actually answered a question that came in from one of our viewers who, I think if it boils down to it, was asking, mediate before or after discovery? And it sounds like
I think it's hard to,
the better.
I think it's hard to give hard and fast rules. I think the key is that on the one hand, if it's going to be a real effort to find a final resolution, the parties are going to have to be far enough along in their own understanding of the matter to feel that they can assess their positions, and where counsel feel they can give advice they're prepared to stand by to their respective clients. On the other hand, I think ideally you want that to happen before you started to spend enormous sums of money on the document production and oral discovery phase of litigation. So I think for a settlement-oriented mediation, there's really kind of a sweet spot in there where parties either already know enough or through the mediation process will learn enough about their respective positions. And mediation can play a very important role in that latter piece. But they've got to get to where they can feel confident giving the advice, but hopefully before they've started to spend huge amounts of time and money on the resolution process.
There's another question I'd like to ask that obviously has drawn a lot of attention, in my view, quite properly, which is how do we get more diversity and include more generally unrepresented people among the pool of well-respected arbitrators and mediators? I think if it's fair to say that if you went and looked at all sort of the major rosters, it's not luckily exclusively white men anymore, but still prevalently so. How do we do better?
Yeah. Well, as the only woman on the panel, I'll jump in. I agree that we don't have much diversity, and there are very, very few women in this business, and there's a handful in the United States, Australia, England. You find them, and they do very well. But I don't know why there are not more. I think women are very, very well suited to this, equally, or with men, they're used to looking for ways to resolve issues or whatever. So I just think we need to keep pushing. Our places like Arbitration Place are pushing it. We need to get more women into it. And I think that we need to talk to young women lawyers who may not realize that there are huge opportunities out there. And, when they're thinking about their career and how they want it to develop as they emerge from law school, how many put mediation or arbitration up there? There's something that's not registering probably on their radar at that point. So when I've spoken about this on panels, I've said, get to the people in the law schools or the graduating classes and familiarize them with the importance of dispute resolution as an element of our legal system and all the different aspects dispute resolution can have. And it's not just about trials and courts, it's about many other possible ways to bring people together, such as mediation, arbitration, etc. And this can be a career for you. You can help people by helping them to resolve their disputes. I think if we can start that discussion going at a lower level, we will get more diversity, not only gender diversity, but ethnic diversity, etc.
Yeah. But just to chime in, Bev had mentioned earlier the benefit of having people from different legal traditions on the panel, and it's exactly the same for having gender diversity, racial diversity, sexual orientation. There's so much input that we have in our society. It should be reflected in the decision makers, and not that they will have a different perception of contract law, but there should be no reason why they're automatically excluded. So the choice has to actually come from those that are actually inside the system. The arbitrators recommend other people. They're the ones who can make the opportunities by naming a young arbitrator as a tribunal secretary to cut his or her teeth onto the matter. A few years ago, I was on a panel as a party nominated, and there was another senior arbitrator, and we were supposed to get together and choose an arbitrator chair. And for strategic reasons, we couldn't, because to choose one meant that we were favoring a position. It was very complex, but we basically in the first 2 minutes said, let's not decide, we'll let the institution. But I said, how about we name this young woman as the arbitrator chair? And he says, well, what do you mean? And I said, well, because she's great. And he said, well, she's much younger than us. I said, I would hope so, because of our age. So he said no. And then 30 days later, the institution advises us that since we hadn't decided, they're going to name, and they named her. And she was wonderful. She was absolutely wonderful, and bullied the other parties into settling after a few procedural orders. So it was remarkably good. I just did a lengthy paper, and I used the word she as the arbitrator throughout the whole paper. And I got comments from a couple of the people I'd shared it with, and two of the fellows said, why do you refer to the arbitrator as she? And I said, because women arbitrate. He said, yeah, but you should say she or he. And I said, well, years ago, we didn't say, we only said he. Can't we say she now? And I said, well, I'd feel more comfortable if you did she or her. And I said, well, it's not your paper, and it's going to be she. So I think that's the way. And last thing is you have some people trying to compete, and you're all out there listening, is people who only have boardroom experience. And I say only. You're trying to compete with people like judges like Tom and Beverly, or me with 25 years of litigation experience. And I've heard one woman contacted me from the States and said, I only have boardroom experience. And I said, I have none. I actually have only sat in a few times at the board level. You'd be perfect. You'd be a deal maker. You'd be approaching it from the user's point of view. So she redid her website and now is getting much more calls because people see her value.
Those are very heartening stories.
Yeah.
Thank you. So Sanjeev is going to pop back on and thank you formally for your participation. But please let me add my thanks. It's been wonderful doing this with you and preparing for it. And usually you get a standing ovation, but obviously that doesn't quite work in the Zoom environment. But I've been watching the participant numbers on Zoom, and this is the equivalent. Almost everybody who registered has shown up, which is remarkable. And almost everybody who was here with us at the start is still here. And again, that's very unusual. So I think in the Zoom environment, that's the equivalent of a long-standing ovation. So thank you. Sanjeev, we'll thank you more in a second. But just so that everybody knows, we will be circulating not just the feedback forms and CLE information, but also we'll provide a few sample clauses that are really just meant as a starting point for you to help craft. But this way you start with something skinny and not the 4 or 5 page type clause that Dan described. So thank you again all. And Sanjeev, if you want to pop back on.
Sure. Thanks very much, Peter. You're right. We had a very large audience today from all across Ontario. I want to thank our panel today for providing their insight and expertise, as well as you, Peter, our moderator, for guiding the discussion in a manner that was very helpful for in-house counsel. There was just so many bits of information in there that I am certain it's going to help us all. And undoubtedly, we're all going to be involved in some form of alternate dispute resolution. So all of this sage advice will serve us very well. I want to thank Goodmans for their generosity in hosting today's event. We greatly appreciate Goodmans' contributions in making this webinar happen. I want to also take the opportunity to ask everyone to provide their feedback on today's program. In the chat function, there's a link to the feedback form. Also, Goodmans has provided a link with your proof of attendance and information on how to report towards your LSO mandatory CPD hours. Today's program qualifies for 1 hour of substantive content. Finally, with the conclusion of today's program, we look forward to our next program on November the 19th, which will focus on intellectual property issues for in-house counsel. Please watch out for an email from ACC Ontario for your invitation. So thank you to the in-house counsel who joined us today. We invited a few non-members to join us today, so hopefully you liked what you saw and you will choose to join the ACC. With that, today's webinar has come to an end, and I wish everyone a great day. Bye-bye.
Thank you, everybody. Take care and stay safe.
Bye.
Bye-bye.